Thank you for joining Mayer Brown's Joint Venture and Strategic Alliances practice for our informational webinar series. My name is Brad Peterson, and I'm delighted to participate with my partners on this call. I am a partner in Mayer Brown's Chicago office and one of the leaders of our Joint Venture and Strategic Alliances practice. I also lead our Technology Transactions practice. Our Joint Venture and Strategic Alliances practice comprises attorneys with interdisciplinary capabilities that our clients need to help them to establish and grow successful joint ventures and strategic alliances, from the early planning and strategy stages to formation and operation, and in some cases, as well as litigation and exit. Our presentation today will focus on antitrust and anti-competition issues in joint ventures and other competitor collaborations, and specifically how to mitigate risks by careful planning and implementing appropriate guidelines. We will be conducting webinars covering additional topics on joint ventures and strategic alliances throughout the year, and we hope that you will be able to join us for those upcoming webinars. You can also find many past programs on our JVSA practice on www.mayerbrown.com. Our goal is to provide practical and strategic advice to help you to establish and grow successful joint ventures and strategic alliances. A couple of administrative matters and some introductions, and then we'll get started. This webinar is being recorded. In a day or so, we will be sending you an email with a link which you can use to listen to the presentation again or to share it with colleagues. Also, for those of you who are obtaining continuing legal education or CLE credit for this program, we will announce the event code in the middle and again at the end of this program. If you do have a question, please type out your question in the chat section of the WebEx screen. We will answer questions on this call, time permitting, at the end of the call, or follow up with you after the presentation if our time expires. I'm pleased to introduce today's presenters. Joining me today are Scott Perlman and Oral Pottinger of Mayer Brown's Antitrust and Competition practice. Both Scott and Oral regularly advise clients on joint ventures, strategic alliances, mergers, acquisitions, and other transactions, as well as on antitrust litigation and antitrust counseling. With that, I would like to turn the call over to Scott to begin the presentation.
Thanks, Brad. Hello, everybody. Today we're going to cover two general topic areas. First, Oral is going to provide an overview of the U.S. antitrust laws and how they're enforced. And then I'm going to focus in on how these laws are applied to the formation and operation of joint ventures and other collaborations among competitors, including some of the practical issues that come up when we advise clients. Oral?
Thanks, Scott. Well, we had our pictures up there a little while ago. What we're going to talk about, first of all, are what are the antitrust laws. Essentially, the purpose of antitrust law is to preserve and promote business competition. The reason behind this is to best serve the interests of consumers. Essentially, it's about making sure that consumers get the best deal. On the other hand, if competition is reduced or restrained, the economy does not do well or does not work as well, and thus consumer welfare suffers. So essentially, what we're trying to do is achieve through antitrust law is more competition, more products and services, lower prices, and better service and quality. That's essentially the purpose behind our antitrust laws in the U.S. Now, the purpose of antitrust laws, specifically in the U.S., is the process of protecting competition. It's not to protect specifically a competitor. So even if a competitor is lost, say because they're unable to sustain their business and competitors drop out of a market, even during the course, if those competitors drop out and there's only one competitor left, antitrust laws would not apply. However, what antitrust law does seek to do is to promote, like I said, consumer welfare. antitrust law does not seek to protect specific competitors, as I mentioned, but it seeks to protect consumer welfare by stop the activity that will raise prices or diminish the quantity or quality of products and services. Now, there are some key terms and concepts that we need to understand if we're going to have an understanding of antitrust law. First is market power. Market power deals with the ability of a firm or a group of competitors acting as a cartel by conspiring with each other to increase the price of products, services above competitive levels, to reduce quality or innovation below competitive level or exclude competition, i.e. the ability to cause anti-competitive effects. Generally, market power is required to demonstrate that there is an antitrust violation. However, there is some conduct that we will discuss later that does not even require market power. They're considered illegal in and of themselves. Another key term or concept is pro-competitive activity. These are activities that enhances a firm's ability to lower prices or increase output, could also increase innovation, and these are seen as benefits of competition. Some other key concepts in terms are per se and rule of reason. And these are two general categories of activities that can violate the antitrust laws. Per se illegal activities are automatically legal. Essentially, go to jail, go directly to jail, do not pass go, do not collect $200. These are activities that almost always are anti-competitive. The classic example of per se illegal activity is price fixing. The second category of activities are evaluated under the rule of reason. Essentially, this is a balancing of potential pro-competitive benefits and anti-competitive effects. And essentially, what you're doing is weighing the benefits versus what could be considered harm to consumers.
Yeah, and this is Scott. The way that works as a practical matter usually is first you'll look to see, are there any potential anti-competitive effects from the activity? If not, that's pretty much the end of the story. If there are potential anti-competitive effects, then you would look at whether there are pro-competitive effects that may outweigh those.
Now we're going to deal with some of the specific prohibitions under existing case law and statutes. First of all, Section 1 of the Sherman Act deals with agreements between competitors. Generally, if someone violates Section 1 of the Sherman Act, it means that there is an agreement that's in place between competitors. It could be explicit, it could be implicit, and additionally, these violations it's not a single actor, it's multiple actors, multiple companies. Some examples of a Section 1 violation would include price fixing or output reduction, bid rigging, market allocation. Essentially, someone's dividing up a territory, someone's taking east versus west, customer allocation, and group boycotts. Now, some of these you need market power in order for it to be a violation. For example, group boycotts, if a group of competitors get together, but they only control a small portion of the market, say 5 to 10% of the market, and they're getting together to restrict output, doesn't impact the market in any way, doesn't impact prices, then that's not going to be considered a per se violation. There's certainly other elements that will come into effect. So per se violations, they can also result in criminal liability, and we're going to discuss that a little bit later as well. There also, under Section 1 of the Sherman Act, there could be also a rule of reason analysis. And typically this would apply to mergers, legitimate joint ventures, some exclusive dealing contracts, bundled or multi-product discounts, some vertical agreements as well. One of the items that obviously we're discussing today is joint ventures. And Scott, did you want to mention something specifically about that?
Yeah, one thing that's important to note is even some of the traditionally per se violations may be judged under the rule of reason in the context of a joint venture. In particular, so if you have a joint venture that's formed by competitors and then they're going to agree together on the price for the products produced by the joint venture, in most contexts, competitors agreeing on prices is price fixing. It's per se illegal. But if they're agreeing on the price of a joint venture product because that's necessary for the joint venture to provide, say, a new product or something pro-competitive, that agreement would be judged under the rule of reason, again, because it's ancillary to the pro-competitive activity of the joint venture.
I mentioned exclusive dealing. Now, exclusive dealing can result, for example, when a seller agrees to give a customer a large discount in return for a customer agreeing not to purchase a particular product or service from another supplier. In general, these contracts they can be considered pro-competitive and can result in efficiencies from perhaps for large volumes of product, and then it could also lead to lower prices. Now, these can also raise anti-competitive concerns if the contract in question forecloses a substantial portion of the market. So say if it's with someone who's a market leader within the industry and they are precluding other competitors from being able to enter the market because of that exclusive deal, then that could be considered as anti-competitive. So generally, if the contract forecloses less than 30 to 40% of the market, is unlikely to be anti-competitive. However, if market power exceeds 30 to 40%, then you need to look more closely, and there's other factors to consider. Some of these factors are listed here on the screen. Typically, if the exclusive dealing contract is less than 1 year, it generally doesn't present any issues. More than 3 years generally can present some problems. Whether there are remaining sales available in the market are sufficient to enable competitors to remain in business, that would also be a mitigating factor. Ease with which existing competitors can expand. Say if there's competitors that are either operating on the fringe or that are already in the market that could easily expand to defeat any sort of market power, then that could be considered a mitigating factor as well. The case that we mentioned here in terms of Beltone, this is a case from the 1980s dealing with the FTC that laid out some of the factors in terms of exclusive dealing. And it specifically addresses the prevention of free riding on manufacturer-supplied investments. Essentially, the FTC held that by protecting Beltone's promotional investments, the exclusive was justified because it encouraged Beltone to make promotional investments. So that was seen as a pro-competitive benefit. Unlike Section 1, Section 2 of the Sherman Act, the primary focus is on single firm conduct. And Section 2 prohibits monopolization, attempted monopolization, and conspiracies to monopolize. So it is important to note under Section 2, having a monopoly alone is not a violation. So if the monopoly power was gained or the monopolist has maintained monopoly status through anti-competitive behavior, this often involves excluding competitors. However, if they obtain that monopoly position by, as some of the case law says, business acumen or just by being better than the rest of their competition, then that is not a violation of antitrust law. So the focus is on the unlawful use of market power. How did they obtain that market power? And typically, monopolization requires significant market share, generally above 70%. Now, attempted monopolization is just essentially someone trying to monopolize, and that generally is seen as someone that has a decent market share, generally around 50%. Now, the different types of exclusionary conduct that can violate Section 2 includes exclusive contracts, bundled rebates, predatory pricing, essentially pricing below cost in order to try to force your competitors on the market, abuse of a patent or other behavior that tends to exclude or disadvantage competitors. It's also important to point out that activities legal when done by a party without monopoly power may also violate Section 2 if done by someone that has a monopoly position. And this can also come into play with joint ventures.
Yeah, a couple of things here particularly relevant to the joint ventures. One is the formation. Although Section 2 generally focuses on single firm conduct, there is a conduct of conspiracies to monopolize, and the formation of a joint venture, depending on various facts, including the market shares of the parties, could constitute a conspiracy to monopolize. Also, again, if the joint venture is in the position of being potentially being seen as a monopolist, then you've got to pay more attention to some of these same things that Oral was referring to in terms of, if you want to enter into exclusive contracts, could that be seen as an effort to either maintain or expand your monopoly power? Bundled rebates, certain kind of discount programs also can sometimes be viewed as monopolization. So once you've got shares that might lend themselves to the idea that you're a monopolist, you need to look more closely at entering into those sorts of arrangements. And it's not that you can never do it, but you just have to look at how they're structured and keep in mind you may need to make them a little less exclusive, for instance, to protect yourself against claims of monopolization. One other thing I wanted to mention was Section 2, while the primary focus is on monopolization, which is has to do with preserving or expanding monopoly power by a seller, it also applies to the exercise of monopoly power by a buyer. It's called monopsony when it applies to a buyer. And the reason that's relevant to joint ventures is that there are many instances where parties get together and form some sort of a joint purchasing or group purchasing organization. You see this particularly in the healthcare area. Hospitals have formed some rather large group purchasing entities. And the issue that comes up is if somebody's buying enough of, including a joint venture, is buying a large enough percentage of a particular product, it may gain enough power to depress the price of that product to the point where the output of the product, the production of the product, is negatively impacted. So that's the concern that you have about monopsony power. And generally, if you've got an entity that's purchasing more than 30% of a given product, all the sales of a given product, you would start to look more closely at whether monopsony could be an issue. And it could impact things like, again, if you have a group purchasing organization and you want to have minimum purchase commitments or other things that would tend to expand the amount of product that those entities are purchasing, you would have to look, once you reach that level, more than 30%, more closely about whether there's a risk that that could be seen as monopsonization, if you will. Oral?
Thanks, Scott. Another statute that lays out specific prohibitions in terms of antitrust law is Section 7 of the Clayton Act. Now, Section 7 of the Clayton Act prohibits mergers, acquisitions, joint ventures that may substantially lessen competition or tend to create a monopoly. So it's not even dealing with actual conduct today in the marketplace. It's conduct that could foreseeably happen as a result of some sort of combination. So the primary concern is whether competition tends to create market power or make it easier to exercise market power. So once again, it's future looking. Now, Section 3 of the Clayton Act, it prohibits same or similar activities as those prohibited by Section 1 of the Sherman Act. However, it deals specifically with certain activities that lessen competition or lead to the creation of monopoly, including exclusive dealing, tying, and reciprocal dealing. Now, reciprocal dealing has to do with an arrangement in which a party with greater economic power agrees to buy a product from a seller if that seller buys something in return. So a quid pro quo. Another statute to be aware of is Section 5 of the FTC Act. The FTC Act is a broader statute than the Sherman Act or the Clayton Act, but sometimes the FTC would use this particularly if there are certain conduct that falls outside of Section 1 or Section 2. Section 1 has certain requirements that need to be met in order for there to be Section 1 violation. For example, there needs to be an agreement. But sometimes there can be activity that perhaps an agreement cannot really be proven, but it's caught by this broader statute, Section 5. Now, the various states, they also have antitrust laws, and most of the states have like a baby Sherman Act, if you will, and that they have passed their own competition laws. Many states also have unfair competition laws that are similar to the FTC Act. So it's possible that a company would have simultaneous federal and state antitrust enforcement going on at the same time. And often you see that in merger cases where the group of state attorney generals might sign on to have a certain remedy achieved because particularly that business might be operating in their state, or it could be a conduct violation where a company is fined because of their conduct and there has particular effects in particular states, and so you might have enforcement by the state antitrust enforcement agency as well. Now, as I mentioned, the antitrust laws are generally enforced by the federal agencies, the Department of Justice, which enforces the Sherman Act, the Clayton Act, and they also do criminal and civil enforcement authority. Now, the FTC, the Federal Trade Commission, they enforce the Sherman Act, Clayton Act, the FTC Act, but they only do civil enforcement. They do not do criminal enforcement. If the FTC enters into investigation and at least a criminal charges, it's something that DOJ would prosecute. Now, the state attorney generals, they also, as I mentioned, they also enforce the antitrust laws. And there are also private actions, whether it be class actions or private entities or industries that would bring antitrust suits under these statutes.
Yeah. Scott, one other point on federal enforcement is that under the Hart-Scott-Rodino Act, which is a federal statute, parties to mergers, acquisitions, as well as the formation of joint ventures may be required to notify those transactions to the Department of Justice and the FTC, depending on meeting certain dollar thresholds that involve the size of the deal and the size of the parties. Now, after both parties are required, both the buyer and seller, and in a joint venture, all the investors potentially would be required to submit Hart-Scott-Rodino filings to the government. Once they do that, they have to observe a waiting period, which is usually 30 days, before they can consummate the transaction. And the purpose of the waiting period is to give the agencies an opportunity to investigate and possibly challenge the transaction if they believe it's likely to be anti-competitive. And ultimately, if they come to that conclusion, they could seek an injunction in court to prevent the parties from consummating the transaction.
Okay, thanks, Scott. Now, what happens if you violate these various statutes or these various antitrust laws? I mean, there are real consequences. There's jail time, there are criminal fines, there can be civil damages, there can be injunctive relief to prohibit those same conduct or actions taking place in the future. So in terms of companies or corporations, there can be fines up to $100 million or double the gain or loss. There could be imprisonment up to 10 years for individuals, and this is not just U.S. nationals. This could be foreign nationals as well. And there could be private lawsuits, and plaintiffs can receive up to treble damages, triple the amount the actual compensatory damages. So obviously there are significant consequences if someone or a company runs afoul of the antitrust laws. There are a couple of charts that just show the enforcement trends
in recent years. Fines, as you can see, shot way up in 2015 and went back down, but kind of the trend has been increasing. And the next slide deals with jail time, and again, that's kind of been increasing somewhat over the years.
Yeah, and in particular with, even though it went down in 2016, in 2017, it's likely to shoot back up again. There have been a number of fines in fiscal year 2017. We're at over nearly $2.6 billion in fines, and those are mostly related to the foreign currency exchange, the manipulation by certain banks of foreign exchange rates.
And if parties, if you're wondering, whether the new administration is likely to result in significantly different numbers on those, it tends to be, well, it's a little hard to predict exactly what this new administration is going to do. There's tended to be pretty much a consensus between both Democrats and Republicans on criminal enforcement, particularly of international cartels that engage usually in some form of price fixing. So I would expect to see those numbers remain at least comparable in the coming years to what they've been in recent years. Okay, well, I'm going to focus now on specific antitrust issues that may be raised by joint ventures and other types of collaborations or alliances among competitors. Now, in doing so, I'm going to refer quite a bit to the Antitrust Guidelines for collaboration among competitors that were issued by the FTC and the Department of Justice in the year 2000. Okay, and these were basically a report by the federal antitrust enforcement agencies providing guidance on how competitors can collaborate without running afoul of the antitrust laws. And they provide guidance on a lot of different aspects of joint ventures and other collaborations, as well as a number of specific examples, some of which I'll be referring to as I go along here. So when you're analyzing a joint venture under the U.S. antitrust laws, the threshold question is whether the joint venture is legitimate. And by legitimate, I mean, is it likely to have pro-competitive effects, or is it really a cartel dressed up as a joint venture without any pro-competitive effects or efficiencies that may be trying to engage in per se activity. And as we go along, I'll give you some examples of each. But by pro-competitive effects, basically I mean a joint venture that creates a new product or that can achieve a reduction in prices that are passed on, or reduction in costs rather, that are passed on to customers in the form of reduced prices, or other significant efficiencies, each of which the parties could not have achieved on their own, or they only could have achieved on their own at a much greater expense or over a longer period of time. So an example of a pro-competitive joint venture from the guidelines is where two software companies combine their complementary capabilities in order to produce a better word processing program that neither could offer alone. And I'm sure we'd all like to see that. On the other hand, if parties get together and say agree on prices or agree not to compete, or in the example here at the bottom of the slide, they agreed not to use a certain component in the competing products they were selling, and because of that, none of them were able to introduce a new, more innovative product. That would likely be seen as a sham, where they just were getting together and conspiring basically not to compete to reduce their costs, and it likely would be seen as a form of per se illegal activity. Okay, now, in most joint ventures that we see from clients, it's pretty easy to reach the conclusion that they're pro-competitive, and people have legitimate business reasons for wanting to engage in joint venture activity. So assuming you get past that question, you then get into some more complicated questions about whether operation of the joint venture will involve an agreement that could violate the antitrust laws. So as we've said earlier, generally agreements about prices between competitors, agreements by competitors to allocate markets or not to compete, those are viewed as per se violations. In the context of a joint venture, though, such agreements will be seen as, will be evaluated rather under the rule of reason if you can show that they're reasonably necessary to accomplish the joint venture's pro-competitive purposes. and the term used is, are they ancillary to those purposes? So, for instance, on a pricing agreement, again, I have two software companies that are both struggling to market and distribute their products. And they form a joint venture, and through the joint venture, they're going to agree on the prices of those products. If you can show that that pricing agreement is reasonably necessary to encourage the parties to make the investments and devote the resources to making that joint venture successful and achieving its pro-competitive goals, then the agreement on price will be judged under the rule of reason. It's not a per se legal pricing agreement. On the other hand, if you have something like the example here of these car part companies that basically say, I'll sell these parts in even years and you sell these parts in odd numbered years, and we'll never be actually competing against each other in any given year. Something like that, or more likely maybe something where the parties were dividing territories up, again, is going to be seen as a per se legal agreement in many cases, unless you could somehow show it's ancillary to some legitimate benefit of the joint venture. If you get through those questions about legitimacy and whether joint venture agreements raise antitrust concerns, the next issue is really the same issue you would look at with a merger, which is, will the formation of the joint venture confer market power on the parties, on the joint venture partners that would not exist in the absence of the joint venture. And so, the first thing you would look at would be market share and market concentration. And again, when you start to get market shares, combined market shares, say, of more than 35% or so, you probably need to look more closely at whether the joint venture is likely to raise these competitive concerns. But, excuse me, the types of things you would look at if you think the joint venture may have anti-competitive effects because of market power would be who else competes. Well, the first thing is, you look at whether the parties were competing with each other and whether competition would be lost because they're forming the joint venture. Basically, you have one less competitor. And if that's the case, and if the shares are significant, then you would look at who else competes. Do they provide products that customers would likely view as close substitutes? Do they have the capacity available to increase their sales and undercut any price increase that's attempted by the joint venture? And also, how many competitors are out there that could do that? Generally, if you have, say, 4 or 5 viable competitors, it's unlikely that the formation of the joint venture would be seen as a problem. Now, another issue that comes up is if the joint venture partners are going to continue to compete with each other outside of the joint venture, then you have to look at whether the formation of the joint venture may cause a reduction in that competition or give the parties an opportunity to either conspire on things outside the scope of the venture or to exchange information that may tend to reduce the degree to which they compete with each other. So parties may form a joint venture to produce a particular product, but they're going to continue to compete on a number of other products. And what the government would look at in deciding whether there's a danger to the competition taking place on those other products would be things like, does the joint venture allow the parties to continue to compete on those products? Does the joint venture agreement permit them to do that, or does it prohibit it? Do the parties continue to control the assets that would be used to make those other products? Do they retain their own decision-making on competitive issues about those products? And what's the likelihood of information sharing that could raise antitrust concerns? Now, in addition to the guidelines that we've been referring to here, the agencies have also provided guidance to parties that are considering entering into joint ventures through their enforcement actions. And I'm going to talk about a couple of those. The first one is the GM-Toyota production joint venture back in the 80s, and this was a joint venture to manufacture subcompact cars that gave us the Geo and the Prism. The concern about those was, on the part of the government, was would GM stop independent development of small cars? Would the joint venture result in exchanges of sensitive competitive information that were not required for the joint venture's benefits? Those benefits included giving consumers an increased choice of cars and also reducing GM's production costs. The FTC, which was the agency involved, permitted the joint venture to proceed, but it issued an order putting restrictions on the kinds of information that the parties could exchange, in particular, the prices of cars or component parts produced by the joint venture that the parties would market separately, other than for the purpose of a supplier-customer relationship between the joint venture and either GM or Toyota. So that sort of information was restricted. Also, sale or production forecasts and cost information about non-joint venture products, the exchange of that information was restricted. The second example is Boeing and Lockheed Martin, and this took place about 10 years ago. They formed a joint venture to combine the only two suppliers to the U.S. government for heavy to medium launch services to put space vehicles into orbit. Now, the government purchased the space vehicles themselves from three companies, Boeing, Lockheed Martin, and Northrop Grumman. So, in other words, Boeing and Lockheed Martin were vertically integrated into both the launch services and the space vehicles themselves. The concern was that the joint venture was going to create a monopoly with respect to the launch services, but also that the information exchanges between the parties would reduce competition between them, with each other, and with Northrop Grumman for the space vehicles. Now, the benefits were that the Department of Defense supported the joint venture as critical to national security. So if you're going to form a joint venture that's going to create a monopoly, you want to get the Department of Defense in your corner. The FTC, again, permitted the joint venture to proceed, but it issued an order placing a number of restrictions on the joint venture. It was not allowed to provide preferential terms for launch services to Boeing and Lockheed as compared to the terms provided to Northrop Grumman. The order limited the exchange of price and cost and other proprietary information between Boeing and Lockheed Martin and between each of those parties and the joint venture unless it was strictly required for the joint venture's success. And the information exchange had to be limited to Boeing and Lockheed Martin personnel who were not involved in competitive activities with respect to space vehicles. To make sure that these restrictions were effective, the FTC also required the joint venture to maintain separate information systems, separate office locations, and appropriate firewalls from Boeing and Lockheed Martin. And finally, the joint venture was required to design a compliance program and provide training to ensure that these restrictions were observed. I'll just briefly mention there's also guidance that can be gleaned from private antitrust actions involving joint ventures. Briefly, the American Needle case took place several years ago. American Needle was a company that had manufactured products with the NFL logos on it, and then the NFL decided to give an exclusive license to Reebok, so a number of companies, including American Needle, lost their access to the NFL, so of course what they did was sued. And the NFL claimed, hey, you can't sue us under Section 1 of the Sherman Act because we're all one entity. You need an agreement between two or more parties to violate Section 1, and the NFL is just one party. Well, the Supreme Court disagreed. It basically said that the NFL was made up of would-be competitors who were capable of conspiring under Section 1 of the Sherman Act. As a result, that case went on for another 5 years, and through very substantial legal fees before it finally settled in 2015. Now, the last thing we'd like to cover is issues that come up frequently when we're advising parties that are thinking of forming joint ventures. And in particular, parties are often looking for guidance and sometimes guidelines, written guidelines, on the exchange of competitively sensitive information, which usually we're talking about information about pricing, marketing strategy, that sort of thing. So, this comes up most often when either the two joint venture parties compete with each other outside the joint venture, or one or both joint venture parties competes with the joint venture. So, for instance, if the joint venture parties compete with each other, you want to make sure people understand when they're sitting in the room to conduct joint venture business, they should not be talking about their pricing or their marketing strategies for non-joint venture business that they compete on. And also, you need to restrict this type of information both between the joint venture partners and the joint venture itself if one or both of the partners continues to compete with the JV. So some specific situations. Now, under the collaboration guidelines, kind of the general principle is that the joint venture partners' commercially sensitive information should not be shared with the joint venture directors, officers, managers, or employees when the venture and one or more of the parties compete with each other. So types of issues you might have is, let's say you have the same person as a salesperson for both the one of the partners and the joint venture. Can they handle sales for both companies when the venture and the partner are competing with each other? Can they do it to the same customers? And the answer to that generally is going to be no, because that could be viewed as a form of price fixing. You should be using separate individuals. You could use somebody who works for one of the partners, but that should be a person who's not involved in selling the partner products that compete with the joint venture products. And it's possible there could be some exceptions to that, but it really would depend on the specific facts. So generally that would be an issue. Another type of issue is customer asks a JV salesperson to compare the price of the JV product to the price of a competing product sold by partner one. Can the salesperson provide this? What if the salesperson is a partner one employee? Generally, if the customer is giving the partner one information to the salesperson, that's not going to be a problem. Also, if the partner one salesperson is not involved in selling the competing products at partner one, that's going to be okay. But again, if they are involved in doing that, you run into the same issues with the first example. And then, third example is where you have JV partners who are employees working for the joint venture. And again, the idea is they should not be providing joint venture commercially sensitive information to the JV partners or directors or officers of the JV partners. So, for example, customer asks the salesperson for the joint venture, who's a partner one employee, if partner one will reduce his price to meet the JV price. And so the question is, can the partner one salesperson do that? Can they go to partner one officer and director and ask them to do that? And generally speaking, the customer should be speaking to a partner employee who, again, is not involved in selling for either not involved in selling the product for the partner or not involved in selling it for the joint venture. And only partner one executives or directors who are not involved in the joint venture and operating the joint venture ought to get involved in these kinds of pricing information. Finally, one situation we ran into recently was where the same management person was responsible for both the partner's activities, and they also had indirect management responsibility to at least oversee the joint venture activities for that partner, and the partner in the joint venture in some situations competed with each other. So, can you have an arrangement like that? Well, the best advice is that you shouldn't. You should have separate people responsible for each of those things. But sometimes, as a practical matter, that's not possible. So where it's not possible, it's fine, for instance, for that executive to continue to receive and manage competitively sensitive information for the partner's business. But on the joint venture, they should only receive aggregated information that doesn't reveal competitive details. So, for instance, general information about financial performance is fine, but detailed information about non-public pricing would be a concern.
And Scott, in that instance, also market power comes into play in terms of whether they have, market power that would, impact competition.
That's
correct?
That's right. Well, you would certainly look at that in terms of assessing the risk. Sometimes there's not a clear, bright line to some of these things, and you've got to look at, what's the risk versus some of the practical realities of which people you can have involved in these things. So if the joint venture has low market shares and or the partner have low market shares, and particularly if when they're combined they have low market shares, say anything below 30%, the likelihood of a problem is less likely, and so it's less of a risk to have the same person involved. The final thing I'm going to talk about is we sometimes have situations, again, where the joint venture and one or more of the partners are competing with each other, where the parties decide they're going to give the joint venture a right of first refusal. So, for instance, if a customer comes along and wants to buy a particular product. In the first instance, they'll refer the customer to the joint venture, and that's fine. Again, assuming that the joint venture is achieving pro-competitive benefits, for instance, that it can more effectively market the products of the partners than they could do themselves. However, if the customer decides not to purchase from the joint venture, then the two parties should compete for that business as if the joint venture didn't exist, and they should compete with each other as vigorously as if they were completely independent competitors. Okay, so with that, we'd be happy to answer any questions.
Yeah, and Scott, we do have some questions that people have posted, so if we can take these in turn. If anyone has some additional questions, please feel free to post those in the chat. One of the questions that we received is, let me back up a little bit. The question is the pro-competitive effect measured against purchasers of the new product?
Well, generally, when you're talking about a pro-competitive effect, you're talking about something that's going to benefit the customers, consumers. So in that sense, it is, and it's not, we're not talking about coming up with a precise number here. What we're really talking about is, is the joint venture likely to, for instance, market products more effectively or come up with a new product, that's going to benefit consumers, that's better than the products that are out there currently. And, those are the types of things that people usually get together to do jointly because they can't achieve them, or it would be a lot harder to achieve them separately. So it's kind of a quantitative benefit more than something that you're qualifying. But yes, it is with reference to whether the consumers are going to benefit. So if there are cost savings, for instance, but the parties are not planning to pass those on to, customers, the government would tend to discount those.
Okay. A follow-on question, is it anti-competitive if the JV product causes other available products to be removed from the market because the JV's product is better? Well,
that's an interesting question, and there's a real-life example of that. It is certainly legitimate for the joint venture parties, if you're talking about the parties removing a product, it's certainly legitimate for the joint venture parties to agree not to compete with the joint venture if that's necessary for the joint venture to be successful. As a general matter, it gets a little trickier when you're talking about removing existing products from the marketplace. I think there are certainly circumstances where you can justify that. An example of a situation where it was not justified was a number of years ago. You might remember at least if you're of a certain age, the Three Tenors had an album come out and a number of years ago, and it was a big smash hit. And then they had a second Three Tenors album, which I think everybody at the record companies recognized probably wasn't as good. And I should mention, Three Tenors, it was a joint venture between multiple record companies because the different tenors were contracted to different record companies. So anyway, when the second album was cut and it wasn't as good, they agreed with each other to stop marketing the original Three Tenors album, I believe for some period of time, in the hopes that this would boost sales of the new Three Tenors album. And the FTC decided that was not legitimate, and wrote a very extensive opinion on that, laying out principles that they used to look at joint ventures. Now, whether it would have been a different result if the second album was better than the first, I can't say. But that was an example where they didn't think taking existing products off the market was appropriate.
Okay, another question. In addition to consulting with knowledgeable antitrust counsel, is it prudent to discuss scenarios or preliminary plans with the FTC or DOJ in an effort to obtain some assurance or some comfort that the proposed joint venture is not likely considered anti-competitive?
Yeah, generally it's hard to do that for the following reason. There is a process that the agencies have where you can apply for At the FTC, it's called an advisory opinion. At the Justice Department, it's called a business review letter, where you can write in the facts of your situation and ask them, what they think, whether they think it's likely to be a problem. And basically what they'll tell you is whether they would have any current intention to challenge it. And that's particularly been prevalent in the healthcare area, where there were healthcare guidelines created in the mid-90s that invited parties to make those kinds of requests. But you have to, generally, you have to go through that kind of a formal process. And the problem with it is it takes a really long time for them to respond. They'll say that they'll get back to you in 120 days or 180 days, but as a practical matter, it usually takes a lot longer. So, from a practical business standpoint, that often isn't a fruitful way to go. However, between the collaboration guidelines and some of the input that people have received from the government in seeking out these advisory opinions and business review letters, all of which are available online, there is quite a bit of guidance out there on joint ventures. So my advice would be to work with the existing guidance, work with your counsel, and you're probably better off in most situations doing that than trying to get one of these advisory letters. But you really can't just call up the government and say, is this going to be a problem? They're not going to respond to that.
Okay. When we were discussing kind of a dual role, when, say, an employee was at like a JV partner and that he later became like an employee of the joint venture, the question that arose out of that, can the salesperson be a former salesperson from one of the JV partners that has been transferred to the JV due to its skills? There are some potential issues there, but generally speaking, I think you'd have to have a couple of things. One is, they'd have to agree, again, if it's competing products, not to reveal any pricing plans or separate marketing strategies that the partner was going to engage in on its own. But if they're not going to be involved in the partner's competing business in the future, that should be workable. They might need to agree, though, that if they leave the joint venture and they want to go back to the partner, that there would have to be some cooling off period during which the information they've gained from the venture would become stale, if you will, and depending on the industry and so forth, that could be a relatively short period of time, or it could be even a year or two or something like that. So you have to look at that possibility and whether both the partner and the employee are willing to deal with that eventuality, that they might be restricted if they want to go back to the partner. Okay. Before we get to this last final question, one of the questions was whether these materials will be available. Yes, they'll be available and they'll be distributed, and Brad Peterson will provide some more information at the conclusion of this Q&A session. So the last question, if it's not an actual joint venture but more of a manufacturing arrangement, such as an OEM for some products but among competitors, do these same rules apply?
Well, you don't, just to be clear about one thing, you don't have to form an entity to have a joint venture. It really goes to what the functional purposes are of the collaboration. So you could do all that, for instance, in a contractual arrangement without forming a new entity. So if that's the question, then that certainly can be done. It really goes to, again, what's the purpose of the parties getting together? Is it a pro-competitive purpose that's going to benefit consumers or customers, or is it something that it looks like the parties are doing just to reduce their costs, or basically reduce the degree to which they have to compete with each other in a way that's either not going to benefit consumers or may lead to higher prices or less innovation, those sorts of things.
And that's it for, do you want to field another question, or do you want to?
You may be wondering, some of the examples in the guidelines of joint ventures that are illegal may seem a little far out, but this issue actually has come up a lot in the real world in healthcare, where you'll sometimes have physicians getting together and forming organizations for purposes of negotiating with health insurance companies, managed care companies like HMOs. And they'll claim it's a joint venture, but the only thing it's really doing is negotiating jointly on behalf of these sellers of physician services. And the government repeatedly over the last 25 years or so has brought cases, and in most cases entered into consent decrees requiring those parties to break up those arrangements. They're okay if the parties are going to, the competing doctors are going to engage in substantial risk sharing or significant clinical integration, because again, there's a pro-competitive purpose to their getting together. But if it looks like they're just forming a joint negotiating vehicle, that's viewed essentially as per se illegal activity. And while the government hasn't brought criminal claims, they have brought a lot of civil cases breaking up those arrangements. And those principles would apply in a similar fashion to other industries besides healthcare.
And then I think with that, we turn things back over to Brad Peterson.
Thank you, Oral, and thank you, Scott, for a very informative presentation. To our audience, thank you again for dialing in today. As I noted earlier, we will be sending out a link to today's presentation. If you have any other questions, we encourage you to submit them to me or to Scott or to Oral. Thank you again for your participation, and again, be on the lookout for future invitations to other programs from our Joint Ventures and Strategic Alliances practice. Thank you.